turn it over to Mark. Mark, thank you for doing this.
Thanks, Stephen. You may be wondering why a litigator was asked to talk about this topic. I think I'll be able to share with you some anecdotes that will explain why, unfortunately, I think, with inadequate planning or thinking on the part of somebody contemplating death can lead to really a bad situation after death among family members and the like. I think the program mentioned that there are certain things I'd be addressing, but in looking at our crowd, I don't think we need to. And that is the whole notion of, make sure you have an appropriate estate plan in place. Make sure you have what's called a living will, or really advanced directives, so that you can provide for the decision-making that's necessary during near-death circumstance about how you wish to be treated. And that is using all measures imaginable to keep you alive versus reducing down to a very minimum amount of extra care that you may get. And there's nothing difficult about putting that together. In fact, as a lawyer, I can tell you, you don't even need to be a lawyer to do the advanced directives. If you want to just Google it, you can find the appropriate forms in Ohio. In fact, the Franklin County Probate Court provides a very good form to use and instructions about how to deal with it in terms of making your advanced directives, if that's what you wish. So I've taken up 3 minutes of what is my main topic. And that's about all that's necessary, I think. I would imagine most, if not all of you, have gone to an attorney to do your estate planning, either through trust, will, or combination of both. Also have executed advanced directive forms already, so you likely have them in place. I want to talk about some other types of things to consider. And as a lawyer, I'm going to be talking about things that aren't necessarily legal, but instead are kind of the practical considerations that you need to really think about. And that is this. And let me put it this way. I think any attorney who's done significant litigation at some point or another has gotten involved in litigation involving post-death estate wrangling, and unfortunately, typically among family members. And this is the thing that people who are doing estate plans and contemplating death and going to the lawyer don't think about enough. The consequence of it is this. What you can have as an aftermath is something entirely different from what the deceased planner, if you will, would normally expect. One of the most vicious cases I was involved in occurred near the end of my active practice, and ended up in our firm having to even sue our client for a fee. And it involved a family that was very distantly connected. an aged mother with a good bit of money, but not living in the best of conditions. You would think with two siblings or two children, one of whom was a plastic surgeon in California, the other of whom was a non-practicing attorney in Portland, Oregon, that you have intelligent people who could make the administration of the state a very simple matter. As it turned out, both the brother and sister, if you will, basically had despised each other since high school. Both very talented. The brother was a Walnut Hills grad who went on to become an All-American swimmer at Yale and then a noted plastic surgeon. It took a kind of a strange turn in California. He became kind of like a sovereign citizen and didn't pay his taxes. So that was not my client. It didn't matter. The other one was equally bad. The non-practicing attorney was a very difficult human being. I'll give you some insights about practicing law and choosing clients. She came to me with a very interesting story explaining how her mother really loved her and despised the brother who never paid any attention to her, and that's why her estate plan had originally been drafted so that the brother got virtually nothing and she got the millions of dollars. That's not how it ended up. But by the time she came to me, she actually hired and fired 3 lawyers.
And you took it? What was your first name? Yeah, right, yeah.
And I was the general counsel to our law firm, so I would preach to everybody, don't take bad clients. But for some reason I said, oh, I can deal with this person. Well, no. That was not the answer. But you had a situation where the son who was having issues in California actually came back to Cincinnati for the first time in maybe 25 years, and did start taking care of his mother and taking care of himself in the process by taking her off to a lawyer who was not the lawyer for the family, not advising the financial advisor for the family, and miraculously her will was changed, and you know, sometimes you get too greedy. So he got everything except she got the contents of one of the bedrooms, which happened to be their junk room. Yeah. So this resulted in a lawsuit in which we alleged undue influence. He had managed to help himself pretty regularly by using her ATM card to withdraw cash all the time. But both of the individuals were, this is the kind of thing you think maybe you can get it resolved easily enough. Fortunately, there was a really good lawyer from Frost Brown on the other side, and we as lawyers got along beautifully, and ultimately on the eve of a trial managed to work out a settlement that made a lot of sense for everybody, and she got actually the lion's share of the estate. By that point we were benefited by the fact that the brother vanished, was not in contact with the lawyer. Except to say, yeah, sell it, do whatever. But the rest of it, the rest of my story with that is not relevant. She tried to, the morning that the court was going to approve the settlement, say, I never agreed to any of this. And I had to inform her that as an ethical matter, that if she says she didn't, that I would have to testify to the court that she had otherwise stated that she was in agreement with it. So she merrily accepted the settlement that morning, and then thereafter tried to again claim that, well, I shouldn't get a fee, which is in the millions. And so we had to sue her, and we got that worked out finally. The best laid plans, the mother had a good estate plan, but she also seemed to be subject to influences by one or the other of the children. And when you have a situation like that, as the lawyer at least, you've got to be very careful in terms of how you're planning the estate to make sure that you're really reflecting the wishes of the client, of the individual, rather than whoever is trying to pull the strings. In this case, I think there had been a clear history of both of them trying to manipulate her as she was into her 90s. That was kind of, I don't want to say that, that helped cap my career in terms of, I've had enough of this. But close. But in other circumstances, you see situations where it may be unanticipated by the person who's nearing death in terms of estate planning, but it's something, if at least if one is competent enough, you need to be aware of, depending on your own circumstances. One circumstance, and I'm not going to talk about any individual cases, but that I've witnessed in the last few years involves the situation where you have, and for some reason it's always when a mother, happily married couple where the wife dies early, and then the children are already adults, become adults, and the husband remarries. And for whatever reason, it may be too anecdotal to generalize, but you have a situation where there is resentment on the part of the children toward the stepmother now, I guess. And so when the husband dies, the ugliness comes out, and even the best attempt at estate planning, for instance, by the husband in that case, may not be good enough if there's not a real understanding of the personal dynamics that are out there. It's not enough just to basically do the disposition that you would in a will or a trust. But there needs to be other instructions, perhaps, that might lead the way to minimizing whatever could be done. Now, it's very hard in some instances. In one case, for instance, I know the wife who lived on, but during the husband's last year or so, had become sick and looked like she might go. The husband's adult children came to town and whisked him away to the financial advisor to change the disposition on a fairly major asset so that it would go to them as opposed to her. I think the way he was convinced was, well, your wife's on the verge of dying, so why not make this simple? She didn't die, and when he died, it became obvious that a substantial amount had been diverted improperly. And let me say this, in most cases, it doesn't make sense to even fight over it. If you're going to go to court, it's very expensive, and usually not everybody goes away very happy anyway. So you have these terrible situations, and one thing that many lawyers and financial advisors suggest very strongly is that in considering death, that one think more broadly and try to make clear how things should be handled. One lawyer, Joan Berto, is a noted estate planner in Ohio, who actually specializes in gay and lesbian estate planning, which is really hard, but she teaches also at Case Western Reserve, talks about the appropriateness of what she calls the death box. It's she said that's the term she likes to use. Some people think it's a little macabre. You can call it anything you want. But the death box is meant to include everything that the person who's contemplating death wishes to say or have done upon death. And this means that you consider what letters, for instance, or what directives you may want to give individuals, children, friends, whatever. It can be, and that can be nothing more. It can be something that's just an expression of how you feel about the person. But it also could be another way to communicate how you would like things to be handled, if you will, sort of a footnote to an estate plan, which is really saying, hey, don't fight about it. This is how I want things done. Particularly when you're talking about personal belongings, which becomes a real area of fighting over what's been in the ancestral home forever, who gets what. It's a good way to have a listing of how that should be done. So that could include things that on the outside people would consider to be minutia, that wouldn't be in a will, but could be very important to how things roll out. Because in many cases, it's not the issue of who gets what percentage of an estate, but it's, who gets that grandfather's clock that has been with us for, 200 years, in which I remember every Christmas morning waking me up, that type of thing. So something like that included in what we'll call the death box. It can be a way to write a directive that really reinforces or puts context to your advance directive, your living will. about, well, this is what I've said, this is what I really mean. Or, it can even be an expression of, I've done a living will. That's how I think I want things to be done. But when the time comes, it's up to you two, or you three, or whatever, to make the decision, because I don't know. I remember we had a senior partner in our law firm when I was quite young who made the point, said, yeah, take no extra measures. And then as he got closer to it, I said, no, do everything you can think of. Forget what I said. And this becomes very difficult for the healthcare professionals to really deal with. So the more explanation that can be afforded in that way, it can be helpful to how things are done. Also, you don't have control necessarily over what sort of healthcare facility you end up in. And what you have as an advance directive may actually be contrary to what the philosophy is of the facility where you end up. And they may say, we are not going to adhere to this. Joan Berta, the state planner, said she's run into that situation several times, particularly, with those who end up in Catholic institutions. It may not be consistent with beliefs of others. I have to say, on a personal level, my mother ended up at St. Margaret Hall in her latter days, and Catholic or not, they were very careful about how they dealt with her, and when no extraordinary measures were to be taken, no extraordinary measures were really taken, and it was a peaceful ending. So, but this is the sort of thing that you don't know what's going to happen sometimes until it's almost too late. So it's something to think about as you are considering what you put in this box. And one of the things that's interesting, I was brought up in the profession, when you do a will for somebody. By the way, the last time I did a will for anybody was about 1976. But the will, make sure it's in the safe deposit box, and whatever you got in there, put in the safe deposit box. Well, if you put something in the safe deposit box before an estate is open, nobody can get into it. Right. And sometimes you open up that safe deposit box, 3 months later after the will's been admitted to probate, and you find all these directions from the decedent, and you say, didn't want to be cremated. Well, it's too late. Oops. or even as again, more specific. He wanted these hymns to be sung at the funeral. Well, a hymn's a hymn. So it's important.
We have countless situations where the church has a file that the person left, and the children are like, it often becomes, Mom loved the church, the kids not so much, so they don't. I'm all the time. So we try to say, well, there's a file where your mother or your father said they wanted X, Y, Z. Oh, well, that's not really important to us. Just so you know, as you're preparing, your kids may not have the same.
Well, the other thing too is, there have been situations where basically the advance directives, the living will, is stuffed away in, some safe deposit box, And sometimes nobody else even knows where the safe deposit box is. So the concept of the death box is you're putting all this stuff in the way you want things done. You want to give comprehensively whatever directives you want in it to people and how things will be disposed of.
Passwords.
Passwords, yes. Well, it should, but the box itself needs to be not secure. And you need to tell people where it is. So when the time comes, I can,
Find it.
Aaron will know where the box is. Of course, I'm not good at this. I didn't even have an estate plan until, 5 years ago or whatever. Larry.
As a firefighter, please, if you do not resuscitate orders, keep one at home and make sure the nursing home has one right there. Because without that order, we're going to resuscitate.
Well, and this raises one other. Again, in the old days, Larry, you'll remember this, it was if you had an estate plan or whatever, you don't make copies of anything. This is the real thing. Or the real thing is kept at the lawyer's office. Yeah, guess why? But you don't get to it if that's the case. You can have copies of everything. And it's best. And so, the answer is you can do a whole lot to help guide people at a horrible time as to how they should act and what things they should do. Good friend of ours, and a very good lawyer in Louisville, got COVID when it first started and was near death. But he's a prolific thinker and writer. He basically spent a couple days. He also went to seminary too, and his wife is a seminary graduate on the board of trustees at Louisville Seminary. He had written out his entire funeral service, not just the hymns, but I mean everything. And fortunately, he didn't need to use it. So, to sum up what I have to say is this. There are a lot of things that you need to think about unless you want to let the chaos flow, or in case, in most cases, there's no chaos that's going to flow. You've got a intact family that understands what needs to be done and that sort of thing. But there are informal ways that you can help direct this. The concept of the death box is something I would recommend to folks as a way of really dealing with some of these issues. So, yes?
So if, I'll use myself, when we lived in Tennessee, we made our wills. Do I need to update those because now I'm in Ohio 10 years later? It's like, it's always, we'll get to it, but is that something that
Probably.
Okay. So just because it's written in one state doesn't mean it works?
Well, it can. There can be issues because in some, not so much now, but in the old days, different states had different formalities, and sometimes that doesn't work. By the way, some of the death box considerations is really would be how you want your body disposed of. Whether you want to be buried. There is a movement, of course, now to have more natural burials where you don't have embalming fluid or anything. You just get buried, and it's like a cowboy in the plains. you go that way. Or in some states have formalized composting for a dead body. And you can even buy kits, but Ohio's not one of them. Yeah.
Mark, if you have a do not resuscitate order, how often does that have to be updated in the state of Ohio? Because I think it differs by state. Maybe I'm wrong, but I had a mother who died in Virginia, and there was a time window in which those documents had to be updated.
I don't know that Ohio has a time limit. I'm not sure.
I know of none.
Yeah, I know of none either, and I think the idea of having a requirement that they be updated is a great idea. I'm not sure our legislature will ever do it, but
When we moved to Ohio 20 years ago roughly, we had to assign a different son to be the primary guy because of these local laws and so forth. So we had to do that. It's a good thing. And my son here is my second son is a doctor too. So when we make him in charge of our decision making, it's comforting for me to know that he understands that everything has got to be. Just main decisions have to be made at the moment, And for example, if I'm reluctant to say do not resuscitate because originally I thought that meant a tube down my throat and pounding on my chest and that sort of thing. It's not that way anymore. It might be just a quick shock and you're back to normal.
yeah.
And you can see your grandkids get married or something like that. So I'm reluctant to be specific. I agree with the way you put it, that we should give it our sort of ways of thinking. It will help the decision makers greatly if they know how we think about things in general.
Well, and the other thing too is, if you're in Oregon, it's one thing where you can choose suicide, basically, legally. Here, some of those decisions could be pretty close to that. And
Yes, indeed.
it's not an easy decision, and you normally do have some pretty serious debate when that time can come, in certain cases at least. Yeah.
Totally ignorant question here, but if you go to a law firm, will there be people within the firm that do family law or estate planning, or there are specialized firms that do that, or how does all that work?
Not all lawyers do estate planning. And some people say they do estate planning. They really don't.
And I don't want to Google it and do that way.
Right. The larger firms typically have estate planning specialists that do things. There are some smaller firms where the attorneys specialize in estate planning, and that's basically all they do. They're excellent. If you're even looking at individual lawyers, if somebody is a member of, the acronym is ACTEC, American College of Trust and Estate Counsel. Somebody who is so designated has demonstrated some real expertise in the area. Stanford Medical School has something called the Letter Project. And if you go online at the medical school there, you can find it. They provide templates for people who want to leave, letters to all sorts of people that you can use at least as your template for how you want to express things to different people. Of course, I think at this point you could probably use Chat GPI and do the same.
Thank you, Mark.
Thanks all.